Not legal advice. Good afternoon. It is May 3rd, I think. Um, Not legal advice being KNOT, by the way. Please share, like, subscribe. Thanks for watching. Today we're going to talk about MMTLP, shockingly, and some other miscellaneous things that might kind of apply. It's going to be a legal update of all the current litigation involving MMTLP that I'm aware of. If my eyes look more squinty than normal, I have like super watery eyes. So if I blink a lot, I apologize. Today's joke, as I promised to do for every video, and I should put jokes in quotation marks. So today's joke: Velcro. What a ripoff. Thanks to little Bruce T out there for these continuing fantastic and funny jokes. Also, today, a special shout out to my very close relatives on the East Coast, as well as Northern California. You know who you are. You know who you are, and thanks for being part of my national fan club. Thanks a lot. So today, just trying to throw a little levity in there, discussing the MMTLP litigation. And this might be a little bit confusing, so if you need to rewatch this 10 or 12 times, feel free to do it. But I'm going to try to kind of put things in a little bit of context so that when you're hearing legal concepts that are confusing, maybe it'll make a little more sense. So here we go. So there's 4 actions that are pending in federal court that I'm aware of. There may be others that I'm not aware of, but I'm aware of 4. It's Rosa's in Florida, it's Jay's in Georgia, it's Allen's in Washington, and it's mine in the Central District of California in Los Angeles. Mark has a petition, which is not a lawsuit, but it's a petition for pre-filing discovery under a New York state statute. And that's in state court in New York. It's not a lawsuit, but it's a pre-filing lawsuit. It has a hearing date as far as I understand. And, if anything I'm stating is incorrect, somebody please correct me. It has a current hearing date of May 30th, 2023. And just as kind of a side issue, if New York state courts operate like California state courts, and I don't know that to be a fact, but they're probably fairly similar. Rulings in state court generally are faster than in federal court, and that's partly because of the hearing procedures. So just to kind of give you a brief rundown about that, and I'm just going to use California as an example. So in state court hearings, almost all of them are ending in an oral argument, so that where the parties counsel will attend a hearing after briefing, and they'll be able to kind of argue about the ruling. And it doesn't have to be a super long hearing, but usually parties are provided some amount of time to argue. And before that argument happens in state court in California, generally a preliminary ruling is issued. And those rulings are pretty firm. So if a judge issues a preliminary ruling, it's unlikely that they will change it, notwithstanding what happens at the oral argument. Therefore, the ruling is already done as of the date of the hearing. In federal court, there's no requirement, and oral arguments happen much less. So as a result, the judges haven't issued formal rulings. And one of the reasons why probably it takes longer in federal court is because it doesn't happen that way. So there may be a hearing date, but there's no formal ruling issued. Therefore, there may be more of a time lag, along with other issues. So that's kind of separates one from the other. That's why in a state action, you might get a faster ruling than in the federal action. So before I get into all the matters, I wanted to try and explain something that I find confusing, so maybe I can help you better understand it when you hear again legal concepts. So there's a state court system in each state. Now, they're all different, but there's a state court system in each state, and they generally have the same format. these state courts deal with the application of each state's particular laws. And so all the states have different laws, so all the state courts are interpreting different laws relating to their particular state. There's a system of trial courts in each state and a system of appellate courts in each state. And the appellate courts are there to make sure that the trial courts in each state applied the law of that state correctly. That's really their job. Appellate courts generally do not look and determine facts. They generally just accept the record of the underlying court and use that and look to see if the lower court applied the law correctly. So there's generally no new testimony in an appellate court. So in California, again, using California as an example, there are 58 counties. Each county has its own trial courts, and there may be more than one. Like in Los Angeles, there's many. The state is split up into districts and divisions, and the appellate courts are divided geographically amongst those districts and the divisions. The final decider of state law is the highest state court. The names are different in different states, which is confusing, of course. In California, the highest state court is the California Supreme Court. But if I went to New York and I talked about the Supreme Court, that would be more aligned with a trial court, which is a lower court. So it can be confusing. So you need to verify in your particular state what court is doing what and at what level. So now moving to Mark's petition. So Mark's petition is not a lawsuit, as I mentioned, but a petition for pre-filing discovery to ascertain the identity of potential defendants for potential future litigation. It's a New York statute, and I'm not a New York lawyer, but the current status of the petition in court by the judge based on the order that I reviewed is that the judge found the allegations in Mark's petition to have been sufficient to issue what is called an order to show cause and setting a hearing date and a briefing schedule for FINRA to show why Mark's petition or a portion of Mark's petition or Mark's petition with any conditions or redactions, etc., should not be granted. It's a preliminary finding. It's not a final ruling. That will come after additional briefing has been filed, which I think there's a brief due on the 19th, which would be an opposition, and I would expect an opposition from FINRA, and I think Mark has an opportunity to reply by the 26th, and then the court will review the paperwork and then have oral argument, at least it's currently scheduled for, I believe, May 30th. So that will be very interesting seeing what happens. Obviously, it puts a lot of pressure on FINRA and creates a risk, which we all like and which helps us all. So props out to you, Mark, and I appreciate your work and efforts. And but on the flip side, also, just as a cautionary remark, be aware that a favorable ruling might contain redactions of personal information or might restrict public disclosure or other conditions. We'll have to see what the ultimate ruling is. Mark may subsequently pursue litigation too, but I will leave that up to him. And thanks again for his work. So we've now gone through the state system and how that state system works, and Mark's case is in the state system. There's also a federal system, and the federal system determines and interprets federal law. So in the United States, there's 94 districts nationally. Those districts are chopped up geographically into 12 circuits. And I'll use again California as an example. So California is in the Ninth Circuit, which is considered to be a liberal circuit generally. And in California, the Ninth Circuit also includes places like Oregon, Washington, Hawaii, I think Guam, and other places. The Ninth Circuit has 15 of the 94 districts. The Los Angeles lies, and where this case that I have lies, It lies within the Central District of California in Los Angeles. In the federal system, the trial courts are the district courts, and the federal appellate courts do and are designed to see if the trial courts, in this case, the district courts, have applied federal law correctly. And again, that's their primary job. The top federal court is the U.S. Supreme Court, which we all have heard of and we're aware of its existence. Generally, the federal courts do not care about the state court's opinion on federal law, and a state court does not care about a federal court's opinion on state law. That is the reasoning, and that's why a state court will completely ignore what a federal court might say, and that's why a ruling in Mark's case, at least as to the order, not as to the content, may not be followed by a federal court in California, for example. If an issue as to a federal law has not been decided by the U.S. Supreme Court, then different federal circuits can have different interpretations of the same law. In state court, until the top state court makes a determination on a specific issue, different courts in that state might interpret a law differently. So until there's a final ruling by the top court as to a federal law or as to a state law, then those laws kind of stay in flux. And obviously, as you go up in courts, so there's many more cases at the trial level than there are at the appellate level that are at the top at the Supreme Court. That's kind of how it goes. So the Supreme Court, for example, decides a relatively small number of cases and a small number of legal issues. So therefore, most stuff has not been finally decided. And obviously new law comes out, so that continues to increase. But that's kind of like the general scenario. So when you hear federal court, now you know that's one system, and state court is one system, and you understand they aren't necessarily the same, and orders may not be interpreted. But information that becomes public is fair game and can be used. So I hope that was very confusing. Feel free to ask any questions. Not hearing any questions, I'm going to move on. But feel free, seriously, reach out if none of that makes sense, and I know it's confusing. And read it, go back and listen to it, because maybe after the fifth or sixth time, it might make some sense. So, as to Rose's case, she has, and this is my understanding of these cases, I have either seen documents or spoken to people. Could be not 100% accurate. This is my understanding as I sit here today. So as to Rose's case, she's filed a motion to amend that I believe is pending. Her judge has not been super expedient for whatever reason. So hopefully a ruling, or maybe a resolution otherwise, will come out within the next 30 days as to her motion. I know there were prior proceedings that the judge had not ruled upon. Unlikely now with the motion to amend for that judge to rule on those, or delayed, or may rule all of them on the same time. We'll have to wait and see. And I obviously wish her success and good luck on it. Jay is filing, or has just filed, his First Amendment complaint in Georgia. So it has not yet been served, and as far as I know, it's not yet been served, and there are no hard dates yet. Alan, I believe, just amended or is amending his complaint, so there's no response date pending, and it's ongoing. In my action, I think we're now approaching filing number 70 in the federal court. I currently have a pending motion to file a Third Amendment complaint against defendants, and that Third Amendment complaint included a lot of the new data from the FOIA reply and the FAQ response. The asserted hearing date on that is May 22nd. It could be subject to the court ruling without a hearing. We don't necessarily know the exact date, but that's where it is currently scheduled. I've received oppositions to my motion from each FINRA, Fidelity, and DTCC. That's three of them. To summarize, and it's important to note that really at no time has any of them asserted that all is well. But as to FINRA and DTCC, although they filed separate oppositions, their primary argument continues to be that they have absolute immunity. And I've thought about that, and if the trial court does uphold immunity, notwithstanding what seems to me to be criminal conduct, I've strongly considered taking that up to the Ninth Circuit and see what they have to say, perhaps make new law about narrowing absolute immunity for SROs. We'll have to see where that goes. I just prefer if the court doesn't grant, it permits me to amend and permits me to pursue it. But if not, I have no interest in not continuing to pursue it. So we will see. I have a brief due as to their oppositions to the motion to amend, and I will be filing 3 replies to their oppositions on or before May 8th, 2023. I haven't decided exactly what I'm going to say, but I will try to address all the arguments they have raised, specifically the immunity issue. And I'm going to also reflect on the new additions, which are the paragraph 14 set of allegations that are included that were belatedly provided through the FOIA reply. And so I'll let you know how that stands after it's filed. So separate and apart from that, I previously filed also a motion for expedited discovery. And in the motion, I sought basically the information contained within the blue sheets, or that the judge certify the information. And that hearing date also happens to be May 22nd. I have received oppositions to my motion for expedited discovery, basically asserting the same grounds, that it's not necessary. And interestingly enough, Fidelity took a position that the blue sheets don't contain share count. And I think they have an attachment that doesn't reference the share count. But when I interestingly enough, I then went to the FINRA website, and on the FAQ, it talks about electronic blue sheets and share count. So seems to me that might be a little contradictory to what Fidelity stated, but that wouldn't be the first time or last time, in my opinion. Not big fans, my opinion. So I have till the 8th to file a reply brief, and I will reply to each of them as to their oppositions. And again, they rely upon the fact Fidelity says, this should be an arbitration. And as you recall, another one of the filings that's outstanding is there's a motion to compel arbitration. I filed an opposition previously, and I'll address it in these proceedings. I just don't think it's appropriate in light of the fact that it appears that Fidelity conspired with the other defendants the week prior to the shutdown and before I bought shares. However, if for any reason I end up and am forced to arbitrate this, I will arbitrate it to its fullest. And I will certainly welcome community members to attest to what occurs at any such proceedings. So that'll be down the road. But I will, notwithstanding whatever happens in federal court, I intend to seek my remedies against the broker. And I will be public about whatever happens and keep everybody apprised. And whatever I learn and whatever strategies that might help others, I'll be happy to pass it on. And whatever mistakes that might occur to me or that I make that I can add on, I will let you know also. But I intend to aggressively pursue them no matter what. So we shall see what happens on the 22nd or when the court rules. We'll see what the court states in general as to the motions. And I obviously am waiting to see what they say about the request for the expedited discovery. And again, I'm asking for a redacted version of the blue sheets, just basically for the share count information. And we shall see. So there's other non-litigation things that are going on in the background that I really can't talk about. I believe one of those avenues will result in a resolution, or alternatively, it'll result in more stepped up litigation by individual parties that will further put the pressure up on the bad guys as I see them. Finally, I really do send out my sympathies, because I do listen to the spaces occasionally, and I'm aware of all the communications. So I send out my sympathies and concerns to all out there who have endured this, to all who have a financial crunch. I really apologize that this is not fast, but I do want to strongly encourage you to understand that there's individuals out there who, at least on the legal front, amongst many fronts, as you know, all the others that are pushing to a resolution, and I really hope and expect a resolution at some point soon. And just note that this is a large group, and I'll just speak to the legal side. We're just going to keep on pushing until we get a positive resolution. So this is not something that's speculative, that's something that somebody could claim it's all right, it's not right. And we will push until somebody makes it right. Anyway, have a great night. Sorry this one was so long. Take care. Be well.